Peter Lamont, who has spoken with us before. Peter is an attorney. He is nationally recognized as a business and commercial litigation attorney. He represents both national as well as international companies. His practice is dedicated to business law, commercial litigation, business success, and development consulting. He is a contributing editor at Architectural Lighting magazine, and he writes a monthly business practice column for Kitchen and Bath Business. Tonight, Peter is here with us to talk about understanding intellectual property, and I would like to introduce Peter Lamont. Thank you.
Now we're going to start getting into where it's really important for you. Next page is difficulties with intellectual property and residential design. So, we've established when you write something, you've got copyright protection. But, let's apply these 3 tests to it. Is it original work? Yes. Has somebody substantially copied your material? Could it be de minimis? No, they took your whole design. You're good. Now, go to the functional test. Is it utilitarian? Is it design? Again, that's not always an easy question. I may tell you I designed this doorway that's artistic in nature, and the court may say it's a doorway. You have to keep in mind one thing, because all the litigation that we handle for designers of all types, judges and juries have no idea what you do. They don't understand it. They don't understand how you charge. They don't understand the benefit unless they hire you. It's called work for hire. Now, those of you who have your own company, consider a work for hire agreement. Because when you hire people, you bring them in, you don't want any ambiguity or confusion. You want to be able to say to a judge or a jury, listen, this work that they've created is mine. Why? Because they signed a work for hire agreement. Because otherwise, you have a dispute. And even if you ultimately win a lawsuit, just like you pointed out, you won, you settled, right? But you spent tens of thousands of dollars. So even if you ultimately are successful in litigating against your employee, you spent tons of money and wasted time. Make them sign a for hire agreement. Consider it. Look at it. Think about it. Now, for those of you who are employees, understand that what you do at work, even if there is not a work for hire agreement, belongs to the company, and you know that because you identify them as such. But there's a gray line where you may feel that something you've done is yours, and the courts have always come down and said, no, it's not. The courts say that when there's ambiguity in a contract, the dispute is decided in favor of the client, the person signing the contract, because they don't understand it. You do because you wrote it or hired someone to write it. Now, my advice should be in everybody's contract. So let's see how an attorney would analyze this and how you should analyze it before you start thinking you've got some protection and you can do something about it. Does your design qualify for copyright protection? Have you met all of the originality, ownership, functionality? Have you met all those criteria? Let's say you did. Yes. My design, everything's right. Yes. Do you hold the copyright? Of course I do. Why? Did you register your copyright? No, it's too much money and it's inconvenient. All right, you still have protection. So far, you're still good in this analysis. Can you prove infringement? There are times, especially on large projects, when you'll have a company that openly steals your design. Those cases are easy. But when you're dealing with residential clients, it can be very hard to prove it. So you do a design and somebody steals it, or they don't want to move forward with you, and you say, but wait a minute, I got my design. I'm sure that they're taking my design and they're going somewhere else and they're getting somebody to build it. What's it going to cost you to litigate that case? I guess I'm done here. Thank you very much.